Good morning to you all. The conversion of money into knowledge we are doing traditionally, and we are rich knowledge-based society, and we are supplying the skills to other companies. If you take any multinational companies, top companies, Indians heading the department or percentage of Indians are more. But the conversion of knowledge into money, into wealth, where we are lacking. And connection between the knowledge into property from the academic institute, still it is lacking behind. And policies are continuously, by Government of India, is amending to meet all these requirements. Now in India, it is very good, well-established legal framework and judicial framework and very good administration of patent. Time to time, for the need to meet the requirement of the international obligation, as well as the public interest, the society's interest, Government of India amending the Act. You can find world-class facilities in the patent office, well-modernized office, and having corporate culture. You can make modernized office, government office, but if there is no corporate culture, then it is a failure of the system. But in the particularly patent office, I can proudly say in Chennai, it is a corporate culture you can find at any time you can walk in. Because if you find any government office, they fix a time to meet the officer. But here, from morning to evening, we meet all the inventors. We clarify the questions over phone. We give replies to all the mails. So that is the quality we maintain. We never obtained or applied for ISO or any other thing, but we try to maintain the quality. Administration may be there, but if it not meet the requirement of the people or service, if it is not giving good quality service to the people, it is of no use. Now, I can assure that Chennai office is continuously giving that quality of service, and in future also, we do continue the same for any type of queries or any type of problems related to IP or any guidance required for IP. And valuation information invention is very broad area, and before starting the invention, the inventor need to search the available databases. To search the available databases, it is not from the public domain or in the research journals, because most of our Indian scientists or academic institutes, they search the journals where you can find most of the time discoveries, not inventions. Where inventions are available. The inventions are available in the patent databases, it is freely available. You can log into any of the website of the patent office, you can find more latest information on your related inventions. And he made another query also where the field of research is going on multiple field, and whether the Government of India or the patent office well equipped to analyze the invention or not. See, time to time, we are recruiting the people in the specific field. In the earlier days, we have only 3 departments: chemistry, electrical, and then mechanical. Now, we are many. Biotechnology, in biotechnology also we have division. In chemistry also we have division. Pharmaceutical science and polymer science and other chemicals we have. In the electrical and electronics, electrical we have separate, IT we have separate experts, and for electronics and communication we have separate experts. So there is no problem for any invention to examine in the patent office. Because government is committed in the TRIPS agreement, it will make the full-fledged product patent system from 2005. Therefore, because of this commitment, time to time, we are changing, we are amending the rules, and also we are recruiting the talented officers through competitive examination. Very recently, Government of India adopted National IPR Policy. In the National IPR Policy, they have introduced 7 components. The 7 objectives are: first, awareness. We do not have much awareness of filing patent. I am hearing my childhood, India is a developing country. I don't know when we will land in the developed status. How the country will land from developing to developed nation is industrial revolution. How industrial revolution will come? When we use our own technology. When we borrow the technology, we are transferring royalty to that company. Ultimately, the revenue for our country, our development becomes very minimum. So the Prime Minister introduced Make in India. The Make in India says that with our own technology, our indigenous technology, the country will prosper. Then only it can reach to the developed nation. For that, first and foremost requirement is awareness, is required to all kind of areas. Now we are going to even school level conducting the awareness program, because it's a grassroots level, it should reach, it should come from the school level and college, universities, industries and universities. This year itself 200 awareness program we have conducted, and in Karnataka also we have conducted few programs in schools and colleges also we have conducted in coordination with FICCI and CAA. So therefore, awareness only can change the status of India. Why? Because through awareness, we can generate IP. The generation of IP required more legal and legislative framework. That legal and legislative framework we are time to time amending, and it is full-fledged patent system to protect all type of creations or intellectual properties in India. The administration, I said, we have 4 patent offices for 4 regions, and trademark office also we have 4 trademark office and 1 at Ahmedabad. Now the method is very simplified. But he said for obtaining a trademark, it required 4 or 5 years or 6 years. Now the pendency has come down 1 month. After filing your application, you will get examination report within a month. That is the status now. I can proudly say, because of the online application, introduction of online filing, you can find out the status online, and the application is examined within a month, and it will be granted, registered in the trademark registry in the next month. That is the status for trademark. And as far as patent is concerned, there is a backlog. We are 3 to 4 years pendency is there, which will come down by March 2018 into 18 months. Why I am saying that 18 months is, it is a statutory period where one application required to be kept secret, because TRIPS agreement says after filing the application, the member countries should disclose the technology to the public by publication at the end of 18 months. Therefore, after 18 months only, you can expect examination report from the patent office. That is a target fixed before the patent office. We are working on it. I hope by March 2018, whatever the pendency is there will come down. Then you can expect the examination report by 18 months, and the entire process will complete within 2 years. That is a good news. And commercialization of trademark, the patent, is a big question mark before the Indian scientist. How to commercialize? Our science always, I can find basic research you do, and he rightly said, you have to do research based on the need of the people and whether people really require the technology. And you have to work for the public, he rightly said. And most of the scientists, they work for themselves. Because if they applied a patent, if they filed a patent in foreign country, they will get a benefit for promotion and other things. Very recently, CSIR has banned filing patent application because 74 crores was spent for filing patent application, and out of 72 crores were spent for filing application in the abroad. And they analyzed less than 7% of the applications are useful. Therefore, it is decided not to file as many as applications. When there is not much use, not commercially viable, it is better to publish. Or you can make only restricted to India. When it is commercially viable all over the world, we can try for the PCT application or filing application in abroad. Otherwise, we can restrict to India. And he raised another question, what is the protection in India? Now, we have patent office, An appeal authority is Intellectual Property Appellate Board. It was not there earlier. And there is the mechanism for filing your infringement in the district court. Then we have mechanism for infringement in High Court, and also we have Supreme Court. So therefore, the another component, another objective of the IPR policy is to make enforcement and adjudication authority. How to protect the IPR. If any dispute comes out of this IPR, how to protect? It is decided to set up a specialized court, IP court. In that court, only IP matter only will be discussed, it will be taken up, and expert will be the IP expert judge, and advocates may be expert in that field. It is the idea of the government. I already decided to set up a specific IP court in the region wise. I don't know the policy matter, but Government of India decided to monitor all these objective of this IPR policy. Government of India set up CEFAM, a committee that is following all the procedures and interministerial difficulties and problems and policies they are making. Very soon it will come into effect. So therefore, all the doubts will be cleared by that time. Further, I would like to tell you, there are 70% of the research fund is by the government. Out of the 70% of the research fund, how the government is expecting? We could find very hardly. Why I want to say is, application filed in India is roughly 45,000 application per year, around 45,000. Out of 45,000 applications, only 20 to 25% application filed by Indian nationals. Others are foreign applications. It is the status now. Then what is the status after independence? After independence, Government of India set up a committee. The last committee was Justice Iyengar committee. It thoroughly studied and submitted a report. That time, mid-60s or 70, mid-60s, it is 20%. What is the difference now? Only the 5%. We have many research institutes. We can claim that very premier institute, many engineering colleges. But what is the status? Only 5% increase from independence to now 2017. So our mindset has to be changed, and we have to go. We have to approach the other land for building our nation. See, Kaveri starts from Gur. For irrigation, we are constructing lot of dams so that the water can be diverted for irrigation. We are doing research. We do not know which direction it goes. Therefore, we have to construct a bridge where we can use it for commercial purpose, or it will be useful for the public. When you have the aim, then only you can reach the goal. Otherwise, it is of no use doing a research. And we do fundamental research. With that fundamental research, multinational companies are taking benefit. With the infrastructure, they do further research. They file a patent which is useful and commercially viable invention. They exploit. Then the inventor who invented the basic research also need to be paid the royalty for that. And also one thing, the scientist or Indian community has to change publication. As soon as they do research, they publish. That mindset need to change. First, you scrutinize the application, whether it's a patentable application or not, then you go for a publication. If you don't scrutinize, then it is of no use. One example I want to give you, there is a university in US, they disclose 9 to 10 invention per week. 9 to 10 invention per week. But it is not, I don't think it is possible 9 to 10 in a month for an Indian university, or 9 to 10 for a year. The target we need to fix ourselves, and we have to work. We have very big knowledge pool. This society is knowledge-based society, our society. So we have to convert this knowledge into commercially viable and useful product. Before filing, we have to make the IPR cell, each and every institute, through which we have to scrutinize the inventions, whether it can be filed a patent or not. If it is a product patent, we can go ahead with the product patent. If it is a process patent, we can go ahead with the process patent. But all we need to evaluate before filing your patent application before filing the patent application. Changes in the patent rule. Now, request for examination definition has been changed. Earlier, request for examination need to be filed before 48 months after filing the application. Now, request for examination also include expedited examination. You can ask, what is expedited examination? He rightly said it's like a third call system. After filing a patent application, you will get a priority date. The request for examination only give you the data priority for examining your application. There are two different. Protection you will get from data filing. Priority for examination you will get from the date of request. Therefore, we advised all the inventors, all the applicants, please file your request for examination along with your application so that it will get the priority date as well as it will also get priority for examination. So once you get the priority for examination, then you can expect the examination report early from the patent office, and it will be, grant also will be easy. Now I said roughly it is 3 to 4 years for scrutinizing your invention. With the expedited examination, you can expect the report from the patent office after filing within a month. There are two conditions has been given for this. Number one, you have to select India as a international searching authority or international preliminary examining authority, or the application shall be a startup application. You are going to start a company or a product. You are going to manufacture the product. But another amendment made is address for service. Earlier, address for service, we used to send it by post. Now, we are communicating to the examination report or maximum through digital network. So you need to give email address. To the email address, all the correspondence will be sent to you. And also phone application, also we are working on it. Now it is introduced only to the agent, they have to disclose the phone number. Now it will come to all the other applicant also. All the informations will come to you by phone with the phone application. We are working on it. Very soon it will come. Now, 90% of the application filed in the patent office by the patent agents or the patent attorneys. So what we have done, patent agent, henceforth, that is from the latest amended rules, May 2016, they have to submit the documents through online. They are barred in filing hard copies. They have to submit the documents online. For other common people, inventors, they can use any route. They can send their documents through Indian Post, they can come and submit the document, or they can submit the document through online. After submitting the application, legal documents like power of attorney need to be submitted original to the patent office within 15 days. If not come, then you need to pay the petition fee and other actions. Now, earlier, the invention related to maybe use of the drug or use of medicine is not patentable in India. So therefore, after filing the application, they amend. Therefore, lot of fee involved. Now we have introduced, at the time of entering the national phase, you can delete the claims as much as you want. That amendment is allowed. What is national phase entry? Or what is PCT application, you may ask. PCT means Patent Cooperation Treaty. India is member of the Patent Cooperation Treaty. Through the Patent Cooperation Treaty, a citizen of India can file a single application to the PCT, and you can claim the priority of Indian application which is already filed in the member countries. Now it is around 140 countries you can claim the priority. Wherever you want, within 30 or 31 months, you can file the application. But earlier we had a Paris Convention route, that application called conventional application. For that, we have only 12 months time. Each and every country, you have to file application within 12 months. Suppose you want to file application in China, you have to translate into Chinese and Japanese and other countries. According to the language, you have to translate. You may not get the time. Keeping in mind, the PCT has come into picture. You can file a single application in PCT. Thereafter, you get time, more time, up to 31 months from the date of filing. You can translate or you can approach the attorney to file the application in the respective offices. Startup. The eligibility for the startup, the company should be a private limited company or a registered partnership company or limited liability partnership company, and it should be within from incorporation, 5 years of incorporation, you can claim startup. The turnover of the company should not exceed 25 crores, and definitely it should work towards the innovation. If the company is not work towards innovation, then definitely it will not consider as a startup company. To submit the company in the name of startup, you have to file a certificate obtained from the DIPP, that is Department of Industrial Policy and Promotion. You can log on to Industrial Policy and Promotion, and the requirement you can find out. The basic requirement for obtaining that certificate is you need to submit a recommendation from the TBI, incubation center you have to submit, or a letter from the funding agency, or publication of the patent application. Any one will do for obtaining permission from the DIPP, a certificate for startup. Why you need a startup application? See, I said for the application filed in India, now we are taking 3 to 4 years. If we go through the startup route, if you want to set up a company, start manufacturing your product, as soon as you file your application, within a month, we'll refer to the examiner. The examiner have to examine the application within 1 month, maximum 2 months. He has to submit a report to the controller. Controller only he is allowed to take 1 month. Therefore, within 3 months, you can expect a report from the office. After that 3 months, you have 6 months time to meet the requirement, to convince, to clarify the doubts in the patent office. Therefore, patent will be granted within a month. Therefore, this is because of the policy, IPR policy, the act was amended, and then it is giving benefit to the Indian citizen, those who want to do an entrepreneur or a startup company. But another scheme was introduced by DIPP is SIPP. The program is called, you can approach any registered attorney in India under SIPP program. He will draft, he will guide for you. For his consultation or for his work, Government of India will pay the amount. It is for patents, it is 25,000, for trademark 10,000, for design it is 6,000. It is, I can say, it's a remarkable amendment in the Indian Patent Act. Normally, government receive payment from the citizen, and for the citizen of India, this is first time government introduced the scheme for the invention, startup invention. This is a fee, 8,000 rupees for an individual, 25,000 for a small scale industries, and 60,000 for a registered company. After filing your startup application, you need to submit for yearly publication under section 24A if it is not published. Why? Because application published only can be examined. The expedited examination we have restricted to 1,000 requests, because according to the volume of the examiner, and we need to do the expedited and other examination. Therefore, the number is restricted to 1,000 for this year, 2016 and 17. It may be increased in the next financial year. There is a separate queue for the expedited examination and normal examination. After examination of the application, if there are certain clarity is required, controller fix a hearing. That hearing you can adjourn 2 times. That is, before 3 days from the date of hearing, you have to take a adjournment by paying a fee. And there is a provision now The hearing may be through video conferencing. Special incentives for the SMEs. Now 50% fee from the other than natural person fee is fixed for small medium enterprises, and even in that 50%, if they file through online, another 10% fee reduction is there. And most of the time, our academic institutions and research institution file a patent application for the academic interest and not for the problem solution or useful for the public. I request all the community to take towards the development of the nation, create IP and protect the IP so that our country will grow with the indigenous technology, and through which our industry will grow. When industry grows, automatically our country will be in the list of developed nations. Thank you very much. Thank you for the opportunity.